Hi, I'm Joseph Eckhart. I'm with the Office of the General Counsel for the Public Employment Relations Board, and I'm here today to present this webinar on unfair practice charge case processing. In this presentation, we'll be talking in general about these four topics. What is an unfair practice charge? The contents of an unfair practice charge, how to file the unfair practice charge, and how unfair practice charges are processed and investigated by PERB's Office of the General Counsel. But we'll start first with our usual disclaimers. The views expressed in this presentation are those of the presenter and are not PERB's official position on any matter. The content is for general informational purposes only and is not legal advice. Please note that some statutes PERB administers have unique characteristics or procedures that may differ from the general principles we'll be talking about today. Please refer to the specific statutes, regulations, precedential decisions, or other legal authorities as appropriate. And you may send questions about this material or PERB's processes to our email address, perbquestions@perb.ca.gov. Also note that this video will be posted on our website within the next few weeks. Next, we'll be going over some background on PERB as we get started. PERB is a quasi-judicial state agency, which means it's an administrative agency that decides certain types of legal disputes. And those disputes have to be brought to PERB rather than to a court of law. Only after PERB makes the initial decision about those cases is there a right of judicial review in court. PERB is headed by up to 5 members who are appointed by the Governor of California, and right now there are 5 appointed members. And PERB has jurisdiction over 17 total statutes. 15 of those are comprehensive collective bargaining statutes covering parts of California's workforce, mostly public sector employees. And there are 2 related statutes that apply to all of those same employees. The workers who are covered by these statutes include employees of K-12 public schools, community colleges, public universities, cities, counties, and local special districts, trial courts, and most of the state civil service. The complete list of the statutes is available on PERB's website, www.perb.ca.gov, under the link for laws and regulations. And just in general, those statutes give employees, and again, it's mostly public employees, the right to form, join, and participate in employee organizations. They also allow those employees to select an employee organization as their exclusive representative. And once an exclusive representative is selected, the statutes give that organization the exclusive right to represent employees and negotiate with the public employer over terms and conditions of employment. And in a typical year, PERB receives about 600 to 700 unfair practice charges. PERB also handles representation petitions, which involve efforts to allow employees to select an employee organization to represent them, or to select a different employee organization, or to remove or decertify their representative. Now we'll talk about our main topic and talk about what is an unfair practice charge. An unfair practice charge is a document alleging a violation of one of the collective bargaining statutes that PERB enforces. Now, PERB's jurisdiction is limited, so even though public employees and public employers are subject to other laws, PERB does not adjudicate violations of those other laws. Some of the common ones we see at PERB are education code, the labor code, including minimum wage and overtime laws, Fair Employment and Housing Act, and other laws that protect individuals from discrimination based on characteristics such as race, religion, sex, gender, or age, and statutes that protect whistleblowers and the Ralph M. Brown Act. None of those are subject to a PERB unfair practice charge. They would either need to be raised at a different agency or in a court of law. And talking a little bit more about what an unfair practice charge is, it may be filed by an employee organization, or an employer. Whoever does file the charge is referred to as the charging party. And a side note here that there is a very rare exception for members of the public to file a charge under the Educational Employment Relations Act and the Higher Education Employer-Employee Relations Act. Those are instances of where public notice is required and members of the public can file charges. A charge can be filed against either an employer or an employee organization, and that party is referred to as the respondent. The respondent cannot be a supervisor, manager, union official, or any other individual. If an individual is alleged to have taken action that violates one of PERB statutes, it has to be proven that they acted as an agent of the employer or the employee organization. And generally, the alleged violation must be of the charging party's own legal rights. So there are circumstances where an employee organization can assert the rights of employees, but individual employees cannot file a charge alleging that another employee's rights have been violated, and they can't file a charge alleging that an employee organization's rights have been violated or the employer's rights have been violated. And now we'll talk more specifically about the function of the unfair practice charge. It is the document that initiates the administrative process at PERB. That process includes the investigation of the charge by the Office of the General Counsel, which is ultimately a decision whether to issue an administrative complaint. If a complaint issues, an informal conference is conducted by a PERB attorney to try to settle the case. And if the case is not settled, there's a formal hearing with an administrative law judge where the charging party has the burden to prove their allegations. And then there are appeals to the board. Those appeals can be after the General Counsel's office decides not to issue a complaint, or if there was a formal hearing and a decision by the administrative law judge, the judge's decisions can be appealed by either party. All right, let's talk about the requirements for the contents of the charge itself. PERB has an unfair practice charge form available on its website that will prompt the charging party for all the required information. And the electronic filing system, which we'll discuss in a minute here, will do the same. But in general, the charge has to include the identity and contact information of both the charging party and the respondent. And if the charge is filed against an employee organization, it must identify the employer so that we can be sure that the employee and the employee organization are within PERB's jurisdiction. And the charge also must specify the statute that the case falls under and the specific statutory provisions or sections of the law that the charging party claims were violated. Some additional requirements for the contents of the charge. The charge must also include a clear and concise statement of the facts and the conduct alleged to be an unfair practice. That's an important requirement, and we'll talk about it more in a moment. It must have a statement of the remedy being requested, and it requires a declaration under penalty of perjury that the facts alleged are true. And finally, it needs to include a proof of service, which is a declaration that the respondent was served with a copy of the charge and any documents attached to the charge. And we'll talk more about service and proof of service in a few minutes as well. All right, let's dive into some of these requirements in more depth, starting with the clear and concise statement of facts. It's very important to emphasize that this needs to be a statement of facts and not speculation or legal conclusions. A good guideline is to provide the who, what, when, where, and how. As best you know, and as specifically as possible, tell us who was involved, what happened, and when it happened. If speculation isn't helpful in the statement of facts, the charging party should allege only the facts that they know. And also legal conclusions or general statements, the respondent violated the law or violated the charging party's rights or discriminated against them are not specific enough. The charge isn't required to cite legal authority or identify specific legal theories. If the charging party does cite legal authority, such as a statute or a case, it must be verified that that authority is accurate. So if the charging party is relying on artificial intelligence or other sources that cite authority, it's important to verify that those citations are correct. But if no legal theories are specified, the investigation will analyze all applicable legal theories. And a practice pointer here is that it's usually not helpful to add marginal legal theories. And this is because the investigation is required to address all the legal theories presented. If there are some legal theories that obviously apply and others that don't apply, the board agent will still have to address the theories that don't apply. And we'll talk about how that's done a little bit later, but the upshot is that it can delay the investigation and the issuance of a complaint if that's appropriate. Finally, exhibits or attachments to the charge are permitted, but note that they do have to be identified and explained in the statement of facts. It can be quite helpful to have the actual documents, such as emails or letters that help explain what happened, or if there's specific language of a collective bargaining agreement or a policy that's relevant to the case, that can be helpful as well. But those exhibits are not a substitute for the clear and concise statement. The statement must explain and identify any relevant exhibits that are attached to the charge. The board agent who is investigating the charge isn't required to comb through those documents to find what may be relevant to the charge. All right, a brief note about something not to include in a charge or any other filing with PERB, which is confidential information. PERB regulations require that sensitive confidential information should be omitted if possible, but at least redacted. This includes social security numbers, taxpayer ID numbers, and financial account numbers. If it's necessary to differentiate certain records, you can include the last 4 digits of these numbers as an identifier. And also, individuals' birth dates should not be included. Everything but the year of birth should be omitted or redacted. And finally, the names of minors should also be redacted, except for the first and last initials can be included if necessary. Now let's talk about when a charge must be filed. The statute of limitations under all PERB statutes is 6 months, which means the charge must be filed within 6 months after the charging party knew or should have known of the alleged conduct. There are some exceptions to this rule, and we'll talk about 3 of them here. The first one is statutory or equitable tolling. And the difference between those two is whether the exception is specifically spelled out in the law that applies. But either way, tolling applies when there's a grievance procedure in a negotiated agreement, usually a collective bargaining agreement or memorandum of understanding. If that same dispute is pursued under the grievance process, the statute of limitations is tolled or paused for however long the process takes. The second exception that we're going to talk about here is the new wrongful act doctrine. This applies when a new violation with independent significance has been committed. That violation has to go beyond merely reiterating a prior policy. And finally, the continuing violation doctrine. This exception applies when there's a rule or a policy that is alleged to be unlawful. And while it may have originally been adopted more than 6 months earlier, it was still in effect during the 6 months before the charge was filed. This is typically for a rule, policy, or directive that violates rights or policies under the collective bargaining statutes that PERB enforces. Now we'll go over some of the basic rules about how to actually file the charge with PERB. There are a couple of different ways. Anyone can electronically file their charge via the public portal, which is available at PERB's website. And e-filing this way is mandatory for any party who is represented by an attorney or by another representative. So an employer or an employee organization must always e-file a charge, and an individual who has an attorney or another person representing them must also e-file. Individuals who are unrepresented are not required to e-file. They may file by bringing the charge in person to a PERB regional office, or by US mail or another delivery service to a PERB office. Those offices are in Sacramento, Oakland, and Glendale, and you can find the addresses on PERB's website. PERB does not accept filings by email or fax, but we do encourage e-filing through the PERB portal as the most convenient way to file a charge. Next, we're going to talk about service of the charge. The charge needs to be served on the respondent. The respondent is entitled to notice of the allegations against it. We don't have any process for filing confidential allegations or charges with PERB. Service of an initial charge must be in person, by mail, or by delivery service. An initial charge cannot be served by email, fax, or any other electronic method. Who can serve the charge? It can be served by anyone who's over 18 years old, including the charging party. It does not need to be served by a hired process server. An important question is who must be served. PERB Regulation 32140 subdivision D identifies the proper recipient of service. And this depends on the type of entity that is being served. If the respondent is a school district, for instance, the recipient can be the superintendent or deputy superintendent. If it's a city, county, or special district, it can be the chief executive officer or the chief legal counsel. And if it's an employee organization, it can be the president of the organization, or if there's no president, another officer of the organization. If you have a specific question, consult the regulation, which does specify for each type of respondent. And finally, a proof of service is required. And a proof of service is a declaration under penalty of perjury by the individual who served the charge. And that document needs to identify the specific method of service, the date of service, and the individual who served. A certificate of mailing or other delivery tracking information doesn't satisfy the proof of service requirement. It must be a declaration signed by the individual who personally delivered or mailed the charge. And what do we do if the charge is submitted, but it doesn't include all the required information, or it was improperly served, or is missing a proof of service? If any of those things happen, PERB will contact the charging party to notify them of deficiencies and give them a chance to correct those deficiencies so that the charge can proceed to an investigation. Now we'll talk about what happens after the charge is properly filed. All the required information is included and the proper proof of service has been provided. If that's the case, the charge will be assigned for investigation by a board agent from the Office of the General Counsel. The board agent is often an attorney, but does not represent either party. Their job is to conduct a neutral investigation or evaluation of the charge and to assist the charging party put their allegations in the proper form. The board agent will issue an introductory letter to the parties, which informs them of the filing and of the procedure that will be followed in the investigation. The letter notifies the respondent of its opportunity to file a position statement, the deadline for it to do so, and the requirements for the position statement. Typically, the deadline is set about 30 days after the introductory letter is sent to the parties. As for the charging party, at this point of the process, once you receive the introductory letter, nothing is required until further notice from PERB. Another item that's covered by the introductory letter is notices of appearance. The letter includes notice of appearance forms, which are also on PERB's website. The parties may file these forms if they want to designate a representative to file and receive documents in the case. The notice must be served on the other party, and once it's filed, the designated representative will be served with all documents from PERB. That is who PERB and the other party should contact about the case. This is a good time to pause and cover extensions of time. Deadlines may be extended for good cause, and this includes the deadline for the position statement. A request for an extension should be filed with the assigned board agent at least 3 days before the deadline and include the reason for the request. In other words, why more time is needed, the other party's position, if it's known, and proof of service on the other party's representative. And the board agent will contact the parties to inform them whether the extension is granted. And we'll talk about some related issues here, which are abeyances and expedite requests. These are requests to either pause the case or to speed it up. So the first one we'll talk about is to place a case in abeyance. The parties may request that a case be placed in abeyance for up to 6 months at a time and 2 years total, unless the board itself approves a longer abeyance. This can sometimes be because the parties are attempting to settle the case, or because they are waiting for a decision in another PERB case, or in an arbitration, or a court case that involves a similar issue. So either party can request an abeyance in those circumstances, or the parties can request it jointly. And on the flip side, what if one or both parties want the case decided faster? A party may request to expedite the charge. At the investigation stage, they can request to expedite at the Office of the General Counsel only, or at all levels of PERB. The request to expedite must be clearly labeled as a motion to expedite, and it needs to specify the criteria justifying expedited treatment. Those criteria Criteria are specified in PERB Regulation 32147 Subdivision B. They include things like a need to preserve the board's ability to issue an effective remedy, addressing irreparable harm to employee or employee organization rights, or if the case involves an important question of law. If a request to expedite is granted, the case receives priority, and there are limits on extensions of time and abeyances. I will also note here, related to abeyances and expedite requests, we often receive questions about how long it will take PERB to investigate a case. There's no set timeline. As we talked about, charges are assigned to a board agent when they're filed, and board agents usually have between 20 and 30 charges assigned at a given time. They also have informal conferences, litigation assignments, and representation cases that may take priority. So a typical processing time is about 7 to 8 months, but some cases are handled more quickly and others take longer. This depends on the board agent's workload and the complexity of the case. Next, we'll continue by talking about the position statement. The respondent is entitled to state its position on the charge, which can include providing facts and legal arguments. Please note, however, that the only facts the investigating attorney will consider are those that do not conflict with the charging party's material factual allegations. So the respondent can give its own side of the story, which can be interesting and useful at other stages of the process. But if the respondent is saying the allegations in the charge are not true, that is not something that can be considered by the board agent in the investigation. The position statement may also raise affirmative defenses, which are based on undisputed facts. Two of the common ones are the charge should be deferred to a contractual arbitration process, or that there has been a contractual waiver of the statutory rights that are alleged to have been violated. And very important, especially if it is providing facts that may affect the investigation, the position statement must be verified under penalty of perjury, and it always must be served on the charging party. The charging party is permitted to file an amended charge during the course of the investigation. The amended charge needs to meet the same procedural requirements as the initial charge, including proof of service and verification under penalty of perjury. And of course, it should be labeled as an amended charge. Note here that while it's not required by PERB regulations, it can be very helpful to indicate any changes to the original charge. This can be done by providing a redlined version of the charge or using strikeouts to show deletions, and bold or underlined or italicized text to show what has been added. But sometimes we do receive an amended charge that doesn't say anything about the previous version of the charge, and if that's the case, the board agent will assume that the amended charge supplements the original charge rather than replacing it. We often get questions from charging parties about whether they should file an amended charge, such as in response to the position statement, or because new events have taken place since the charge was filed. This is a decision that has to be made by the charging party. The board agent cannot advise them on it. If the amendment is to add new allegations that have happened since the charge was filed, the charging party needs to be aware of the 6-month statute of limitations that we talked about earlier. If the amendment is to dispute facts provided in the position statement, note that this is not always necessary or helpful, and that's because, as we talked about, the board agent will assume the charging party's facts are true. But if it is necessary to dispute facts provided by the respondent, then the charging party will be notified, and we'll talk about that process in a couple of minutes. Another downside of filing an amended charge is that the respondent may be given another opportunity to file a position statement. So filing excessive or unnecessary amendments may end up delaying the investigation. We also sometimes have charging parties who would like to provide more information by email or in a phone conversation. It's important to know that the investigation can only rely on information that is filed in the case, verified under penalty of perjury, and served on the respondent. The board agent cannot and will not consider information provided verbally or by email. Now we'll talk about the board agent's investigation or evaluation of the charge. The board agent is tasked with determining whether the charge states a prima facie case. And a prima facie case means that the charge contains sufficient facts that, if proven true at a hearing, would be a timely violation of the applicable statute. So in this process, as we talked a little bit about before, we accept the charging party's factual allegations as true. We don't consider contrary facts provided by the respondent, unless there's no material conflict with the charging party's allegations. As also discussed earlier, we don't accept speculation or legal conclusions. But what we do is we apply the factual allegations to the legal standards under the collective bargaining laws the board enforces. And if those allegations would amount to a violation, then that's a prima facie case. So what happens if the charge does state a prima facie case? If the board agent decides that the allegations in the charge do state a prima facie case, they will usually issue a complaint. The complaint formally lists the key factual allegations from the charge and the provisions of the statute or PERB regulations that the respondent allegedly violated. The complaint doesn't list every fact alleged in the charge, but just those that place the parties on notice of what is at issue in the case. And the complaint is the foundation for the formal hearing before the administrative law judge. It tells the parties and the judge what are the allegations at issue in the case. The complaint is served on both parties with a cover letter, which notifies the respondent of the deadline to file an answer to the complaint. And shortly after the complaint issues, a different board agent will schedule an informal settlement conference to help the parties try to settle the case. For more on that topic of the informal settlement conference, I recommend tuning in for next month's webinar on June 24th, when one of my colleagues from the Office of the General Counsel will be discussing those informal settlement conferences. So that's what happens when the charge does state a prima facie case. But what if it doesn't? What if there's something missing from the charge, or it appears not to have been filed within 6 months after the alleged unlawful conduct, or the conduct that's alleged is not a violation of the statutes that PERB enforces? If the charge doesn't state a prima facie case, the board agent must notify the charging party of the deficiencies. And that is done in a warning letter, which is sent only to the charging party, and it describes why the charge is deficient. The warning letter summarizes the facts and explains why a complaint can't be issued. This can be because the charge doesn't allege all the facts that would be needed to state a violation, or it can be because the board has already decided in a precedential decision that the type of conduct alleged is not a violation. And also note that a warning letter will also be sent in those instances where the respondent can establish an affirmative defense based on undisputed facts. And we'll talk specifically about one of those affirmative defenses in a moment here. Whatever the reason for the warning letter, it gives the charging party a deadline to either amend the charge or request to withdraw the charge. We'll make a brief detour to talk about the affirmative defense that is most frequently successful at the investigation stage, which is that the charge should be deferred to arbitration. The board will generally defer a dispute that is subject to final and binding arbitration if these 3 requirements are met. First, the dispute arises within a stable collective bargaining relationship. Second, the respondent is willing to waive contract-based procedural defenses and proceed to the arbitration. And third, the contract and its meaning lie at the center of the dispute. Now, under some of the statutes that PERB enforces, the deferred charge is dismissed, while under other statutes, the charge is placed in abeyance. In either event, after the arbitration, the charging party can request what's called a repugnancy review, which is to claim that the arbitration was repugnant to the statute. Please note that that review is not available to a respondent who is dissatisfied with the arbitration award. It's only for the charging party. All right, turning back to the general process for the investigation and what happens after the warning letter is issued. If an amended charge is filed in response to the warning letter, the new allegations will be reviewed. And if those allegations cure the deficiencies that were identified in the warning letter, the board agent will issue a complaint. If the amended charge doesn't cure the deficiencies that were identified, or the charging party did not file an amended charge, the board agent issues a dismissal letter. And that letter notifies the charging party of the right to appeal the dismissal to the board itself within 20 days of the dismissal. And now we'll talk about the option to withdraw the charge. The charging party may decide not to pursue the charge. For instance, they may reach a settlement with the respondent, they may independently decide not to pursue the case, or they may decide not to pursue it after receiving a warning letter. If they do decide not to pursue the case, they may file a request to withdraw the charge. The request should state whether the withdrawal is with prejudice or without prejudice. And with prejudice means the charge cannot be refiled, and that's typically following a settlement. Without prejudice means the charge could be refiled, and that's typically when the charging party is voluntarily withdrawn. After receiving the request for withdrawal, the board agent will issue a notice that the charge was withdrawn and the case has been closed. Let's talk about what happens if some allegations in the charge state a prima facie case, but others don't. One of the situations where this happens is we talked about earlier, which is when the charge talks about legal theories that don't apply to the facts. So even if some legal theories do apply, the board agent is still required to address the ones that don't. In that situation, the board agent usually issues a partial warning letter, which identifies the deficient allegations while specifying that the other allegations will be addressed in a separate document. The partial warning letter, like a warning letter, provides an opportunity to amend or withdraw, but it is limited to the deficient allegations. If the charging party does withdraw those allegations, a complaint will issue on the remaining ones. But sometimes the charging party doesn't withdraw, or they don't file an amended charge, or they file an amended charge that doesn't cure the deficiencies. If one of those things happens, the board agent will issue a partial dismissal. The partial dismissal is issued at the same time as the complaint on the remaining allegations, and the partial dismissal may be appealed again within 20 days after the partial dismissal issues, may be appealed to the board while the complaint proceeds to an informal conference and a formal hearing if necessary. But note that the parties can agree to place the complaint portion in abeyance while the partial dismissal is addressed by the board. And of course, if the amended charge does cure the deficiencies identified in the warning letter, then all the allegations will be included in the complaint, meaning they will all go forward. All right, we've covered a lot here, but we have some additional resources available if you have additional questions. Further information is available on our website, www.perb.ca.gov. Look for the drop-down menu for unfair practice charge, and there are 2 pages there with information about the process and a step-by-step guide on how to file the charge. And also under the resources link at the very top, you can select training videos, and there are more videos about charge filing and processing. We also have email addresses where you can contact us, perbquestions@perb.ca.gov. You can email us there to ask procedural questions about how to file an unfair practice charge or questions in general about PERB. For specific questions about using the PERB portal to file a charge or any other documents in the case, please use PERB portal at perb.ca.gov. And finally, if you'd like to contact us by phone, you may dial 916-322-3198. That is our general information line. Leave a message and you will be contacted by a board agent from the General Counsel's office if you need help with questions about a charge. Thank you for joining us today. We covered a lot of ground about what a PERB unfair practice charge is, what information should be included, how to file it, and the process for the General Counsel's office to investigate and decide whether the charge should move forward in PERB's administrative process. Please join us on June 24th for our next webinar, which, as I said, will be about PERB informal settlement conferences, including tips on how to make the most of your mediation in your unfair practice case. Thank you.